Yeah, sure. So, yeah.
Last time the matter came up, it was actually 11th May 2023, came up for mention. And the league counsel, Professor Michael Zekume, was in court. So, and the court said since it's coming up for mention, because penultimate time he came up, the court didn't sit. So the date was given off record. So the court says this matter is coming up for mention. That's his practice that it will be another day will be taken for hearing. Our league counsel, Professor Michael Zekume, was in court, and the date was adjourned. Matter was adjourned for today, for hearing. So we are informed this morning in court that his lordship is not disposed to entertain matters going on for hearing, and or matters that he can only take matters going on for ruling. That's in this case, he's ready to deliver ruling on matters he has taken and judgment. So consequently, the matter has been adjourned. And unfortunately, the league counsel, Professor Michael Zekume, traveled all the way from Calabar to be here this morning for this matter, but unfortunately, the matter didn't go on. So we have no option than to wait till next adjourned date to follow it up. Of course, we know the sister case coming up next week for judgment on 20th of July 2023 for judgment.
So we're coming to that. So give us the substance of this judgment.
This matter actually was filed before the judgment was delivered in our appeal on October 13, 2022. The substance in effect is we're inviting the court to interpret the 11th section of the domestic and international laws, which the federal government grievously violated in an attempt in abduction of Nnamdi Kanu in Kenya and his consequent extraordinary rendition to Nigeria. So the court is invited to interpret those laws and also make pronouncements on reliefs we are seeking for. However, the substance of this case has been settled by the Court of Appeal judgment in principle. So because the questions we are inviting the court to answer in this case has been answered in the positive by the Court of Appeal. So what we are here actually just to inform the court that this question has been answered, and also to grant relief we are seeking for, and make far-reaching pronouncements and damages accruing therefrom. That's all. Thank you. Is it what? We are asking for damages of 50 billion naira on account of that. And also, the most important thing for the federal government to realize about the seriousness of their actions and the illegality of the actions has already been pronounced by Court of Appeal. And so this court is merely inviting to make to be abided by the rules by the government of Court of Appeal.
On the sister case, can you give us that?
No, sister case is an application we filed to compel the SSS to allow Nnamdi Kanu access to his medical doctors in line with the order of the court, and also to avail us of the court records, the medical records, and also the lawyers and the doctors. So this is the substance of the sister case, which is coming up on 20th. And also, remember the court made a pronouncement. This court, Honorable Justice Binta Nyako, made a pronouncement about the manner in which Nnamdi Kanu will be visited. The court said 3 persons must visit him at a go. So, and this order has been roundly violated by the DSS. So, because they changed the entire system, 3 persons are no longer allowed to visit Nnamdi Kanu. So these are part of the issues the court have been invited to interpret and also resolve. Because this is a substitution order of court made by His Lordship Honorable Justice Nyako, and which DSS is violating
Make sure you share this video
with
and
impunity.
let it go viral.
Thank you.
Please like, comment,
God bless you.
and follow.